Ready for the dictation? Start. Registration as multi-system operator on being satisfied that the applicant fulfills the eligibility criteria specified under Rule 11B and the requirements of Rule 11A. The registering authority shall, subject to the terms and conditions specified in Rule 11D and the security clearance from the central government, issue certificate of registration. Stop stanza. It is clear from mere reading of the Rule 11C within bracket 1 that grant of permission is subject to issue of security clearance from the central government to the applicant within bracket appellant in this case. Stop stanza. In this case, admittedly, the appellant failed to obtain the security clearance as provided under Rule 11C of the rules. Stop. It was a mandatory requirement as provided under Rule 11C of the rules. Stop. Since the grant of permission was subject to obtaining of the security clearance from the concerned ministry, the competent authority was justified in cancelling the conditional permission for want of security clearance. Stop stanza. Learned counsel for the appellant, however, argued that the appellant was not afforded any opportunity of hearing before cancelling the permission and therefore the impugned cancellation order is rendered bad in law, having been passed without following the principle of natural justice and fair play. Stop. We find no merit in this submission. Stop stanza. In somewhat similar circumstances, this court, while repelling this submission, laid down the following principles of law in the case of ex-servicemen's protection services Private Limited versus Union of India and others within bracket 2014 5 SCC 409 in para 16 and 17, which read as under. Stop stanza. What is in the interest of national security is not a question of law. Stop. It is a matter of policy. Stop. It is not for the court to decide whether something is in the interest of state or not. Stop. It should be left to the executive. Stop. In the matter of national security is not a question of law. Stop. It is a matter of judgment and policy. Stop. Under the Constitution of the United Kingdom and most other countries, decisions as to whether something is or is not in the interests of national security are not a matter for judicial decision. Stop. They are entrusted to the executive. Stop stanza. Thus, in a situation of national security, a party cannot insist for the strict observance of the principles of natural justice. Stop. In such cases, it is the duty of the court to read into the provide for the statutory exclusion if not expressly provided in the rules governing the field. Stop. Depending on the facts of the particular case, it will, however, be open to the court to satisfy itself whether there were justifiable facts, and in that regard, the court is entitled to call for the files and see whether it is a case where the interest of national security is involved. Stop. Once the state is of the stand that the issue involves national security, the court shall not disclose the reasons to the affected party. Stop.